Broadcasting from the studios of Business RadioX, it's time for Litigators Lounge. This show is brought to you by Hall Booth Smith, guiding clients through challenging workplace legal issues. Now, here are your hosts.
Well, hello, everyone. Thank you for tuning in to this week's episode of Litigators Lounge, where courtroom drama meets the comfort of a casual chat and a cocktail. I'm Jackie Voronov, and I'm here with my phenomenal co-host, Shylie Bannon. How are you today, Shylie?
I'm doing great. How are you, Jackie?
I'm phenomenal. You're phenomenal. I'm like in such a positive, happy, bubbly way about 2025. I'm trying to do the exact opposite of this doomsday vibe that's being put out, these days. I'm just trying to live life, be good.
Well, I'm just glad that I made it through dry January. So
you did.
Here we are, February.
I did not. I was deep into the Litigators Lounge with I guess what's the opposite of wet January?
Sure.
I was in it hard. There's a lot going on in 2025, and the end of 24 had me jonesing for a lychee martini, something fierce. So I don't think I left the lounge.
Well, I'm back in there with you. And I know that you and I get to actually see each other in person next month. I'm very excited about that for the Women in Insurance Executive Summit Conference.
I know. I have it circled on my calendar in a big red Sharpie because I'm so excited. It's been too long. I can't go on with just this podcast relationship of ours. I need to see you in life.
So what are we talking about today, Jackie? What are we going to bring to all of our fans?
So I thought about this and I was like, we need to cover a lot. And I had a really hard time choosing between any one thing. So then I decided, why do I need to choose? Why can't we just talk a little bit about a lot of things and kind of set the stage about where we ended in 2024, and what we can expect to see and what we've already seen taking shape in 2025. I think that this year is the year that employment law decided to hit the gas pedal, quite frankly. I don't know if you feel the same way, but for me, I get this feel like everything's changing at warp speed, and I'm pretty sure that's because it is. It's not just me.
Yes, I went actually in December to go see Timothée Chalamet's Bob Dylan biopic. And all I hear is, as 2025 has started in employment law, is the times they are a changing, sung as by Timothée Chalamet as Bob Dylan. And so we're really in for a wild ride. And every day when I finish work, I pull up the news to find out what new thing has happened while I've been deep in a deposition.
If you're in a deposition, chances are that by the time you wrap up for the day and say you've got no more questions, something's changed. Something out there.
Something has been removed from the EEOC website, even.
Not just the EEOC. I mean, I think in the last month, we've seen new wage laws. We've seen expanded leave policies. We've got AI hiring regulations. We've got the DOL, the EEOC, and the NLRB tripping over each other practically with new rules. And I just feel like, compliance officers everywhere are reconsidering their life choices.
So I think for our listeners today, we have 4 sort of really bigger topics that we're going to touch on, and then some miscellaneous tidbits that we'll leave towards the end and leave them as food for thought as we set the stage for future episodes of Litigators Lounge. And if you're ready to dive right in, I have my drink poured. How about you?
I'm on my second one, if we're confessing.
Okay, well, cheers.
Cheers to that. Let's get into it. Talk to me about the laws.
Topic one. Pay transparency laws. What are they?
What are they? You're asking me?
Yeah, let's start with let's tell our listeners, what is a pay transparency law?
I mean, it's pretty self-explanatory. It's a law that's being passed in states that's requiring employers to be transparent about the salary ranges for the jobs that they're listing. And
So
disclose.
for example, if I go on to LinkedIn and I'm definitely not looking for a new job, but if a job comes up on LinkedIn and I see that it says, in Colorado, in order to comply with pay transparency laws, the expected salary range for this position is X to Y, that's what you're talking about.
That's exactly right. So you have to say the job pays, between $100,000 and $150,000. You're also required to list benefits or any other compensation for a post that you're advertising.
So if I understand correctly, I think that the first states to pass these were, in fact, Colorado and Washington State. I think that started in about 2021. And this year, we have new states enacting those laws, right?
5, if memory serves me. I think it's 5. I know that New Jersey goes into effect in June.
Including your home state. Look at that.
Well, let's be clear. New Jersey is not my home state.
Fact.
Massachusetts is my home state, by way of Ukraine. So, by way of Soviet Union, which is now.
Okay, well, Massachusetts is also enacting laws this year.
It is. Massachusetts is one of the 5. So, and I'm admitted in Massachusetts, so I can tell you all about Mass and New Jersey on another day. It won't be today, but Illinois is in that bucket, Vermont and Minnesota.
And what is the idea behind these pay transparency laws?
It's multifaceted. Also, primarily it's to get pay equity, right? We do live in a time where pay equity has been one of the trending topics. And so the idea is that if the job listings are more transparent, pay equity, not just across gender, but just across race, religion, national origin, it's to level the playing field so that everybody knows what the job pays. And if you're telling people what the job pays, you're going to bridge the gap between, Jane Smith and John Smith.
Are employers worried about this because they feel like it's going to constrain their ability to recruit and to go outside of that range if they find the right candidate and they need to stretch that range? How are employers in general feeling about these pay transparency laws coming into effect?
I'll tell you this, and I can't tell you that I've spoken to all of the employers, but it's just another layer, it's another compliance element. If you're paying people fairly and you're not discriminating against anybody when you're determining the salary of a new hire, you shouldn't be worried about anything and you shouldn't have a problem. This is just more, as far as I'm concerned, administrative. Employers historically, obviously, and recruiters and staffing companies do try to get a deal. And I'm saying that in air quotes. Sometimes you feel like, you've got a really great potential new hire. Let's see if we can, get them for a bargain or get them for a steal. And that has historically been unfair to women, because statistically, women are less likely to negotiate for a higher salary during the recruiting process. Employers, should be aware of this. A lot of the states don't necessarily have a private right of action associated with violations. So they shouldn't be panicking over it, but they should definitely be compliant. And, some have played fast and loose, right? You'll put a salary range and you'll say, well, the job pays between $100 and $250,000. And so technically they're complying and they're playing a little funny with it. And I've seen a lot of that, especially on like hiring boards and job boards, things like Indeed.
Well, I think that if employers are planning on doing that, they're going to have some lawsuits against them soon. We've already seen some class actions on this topic starting to raise their head, especially in Washington State. Amazon and Starbucks got hit with some class action suits about the pay transparency laws out there already.
Oh, I'm not surprised. I mean, if the law passes on January 1, there's a good chance that on January 2, you'll see a complaint filed.
Yeah. Okay. Topic number 2 for this year that we're going to be focusing on: workplace privacy. And this one was really interesting to me: the use of AI in employment decisions like hiring and recruiting. I went into a rabbit hole as I was getting ready for this podcast, researching all of the ways that AI is being used in hiring. Because I still do it the old-fashioned way. I get the resumes, I look at them, I talk to people, and there's no computer that's doing this for me. This is just me. But apparently, in other companies and other employers, they are running resumes through AI generators. They're actually uploading videos. They're having candidates upload videos for AI to analyze and to pre-select candidates, which blew my mind.
It was wild to me. I'm so vintage. It's embarrassing. I've always considered myself to be like, well, my niece will tell me I'm the cool aunt, also in air quotes, but I am not. I can't wrap my head around the fact that like AI, this, technological world where it just you put in a couple factors and then it regurgitates like a robot to do these things for me. I'm not that cool. I've had a thing with it.
You do have an iPhone. It's not a flip phone. So
I mean, I'd rather have a flip phone. It's iPhone and I can't. Yeah.
Do you remember the old days of doing T9 texting?
Yes. And I still have my old flip phone. I can't use it, but if I had the option, I would. How is AI used to do the hiring, though? I mean, is this something that presumably this has to be coming through larger corporations where you're getting hundreds and if not thousands of resumes and they're just trying to, cut down on the administrative costs of reviewing everything?
Some of them, yes. And then actually some companies are offering this as sort of a third-party contracting service so that smaller businesses can take advantage of this as well. So you can actually contract with a third-party company that does AI onboarding and AI selection, and they'll pre-select for a smaller company, for somebody who, for example, doesn't have a full-time recruiting department. It's happening in healthcare. It's happening in the finance sections a lot. And of course, tech companies like to use things like this first. But it goes, obviously, there are a lot of issues with the potential for bias, because if it's training AI to recognize certain facial characteristics or features or vocal intonations, that can unintentionally pre-select out good candidates. And it looks for keywords. So I never really thought that I would have to search engine optimize a resume, but here we are. Resumes are being sort of filtered through these systems, and they're looking for keywords in the resume that give them scores as optimal candidates. So if I don't use the right word to describe something and I use a synonym for it, or if I'm not clearly explaining it in a way that the AI algorithm recognizes it, I might not be selected for that position, which is not good for the candidate, but also means that employers might be missing out as well. So there's obviously a balance in efficiency and quality that's coming out of there, but could also open employers up to some risks. There are states that are actually putting in requirements now that companies disclose what parts of their hiring process are being automated through AI or through computer technology. And that's happening at the state level. That's also happening at the local government level. So it's something that employers really have to be careful about, where they're advertising and where they're locating their offices, making sure that they're complying with those local rules.
How does that did I catch you before correctly? You're saying that they're using facial recognition. So like if a candidate is like overly smiley, or in my case, if I have like resting face, resting blank face, I'm just like a miserable person. The AI will have like a program to say, like, filter that out. The person's not smiling enough. The person is blinking too much. The person is, I don't even know.
Exactly.
Nodding their head too much.
No, you've got it exactly right. And as a woman, I love being told by other people to smile more. And so now for the computer to tell me to smile more, it's so exciting for me.
Oh, wow. That's frightening. I noticed I get like creeped out when they do that at airports now. You see like the biometric facial scanners. I didn't expect that in 2025 we'd be existing in a world where you now have like biometric facial scanning just at a job interview, but it sounds like that's what you're telling me.
Right. Well, speaking of privacy and biometrics, I mean, there's actually more regulations that are coming out in states like Illinois, Texas, and Colorado about biometric privacy laws. And employers have to update biometric notices if they use any kind of biometric data in their workplace or in their places of employment. Wearable technology in the workplace is becoming a big issue in terms of what's monitored. Privacy in the workplace is going to be a really big topic in 2025 and beyond. I think it's a huge thing.
10 years ago, and probably even 5 years ago, I would have considered the term workplace privacy to be a little bit of an oxymoron. I would have told you, you're in the workplace, you've got virtually little to no expectation of privacy. And that has really shifted far. Now there are workplace privacy laws. In New York, for example, monitoring. Monitoring has always been one of those things that you've always expected, right? You're using a company computer, you're on company email, then they tell you in the handbook, you have no expectation of privacy. This is our property, we own it. States like New York and others have rolled out laws that foreclose employers from doing that without notifying the employees and using that in a lawful way. You don't have carte blanche like you used to.
The times they are a changing.
Yeah. But like being the optimist that I am, I can't help but wonder if we're overshooting this with AI and tech, because it sounds like if you have an algorithm that is programmed to say, here's what I want, or here's the characteristics, or here's what I want to weed out, essentially what you're going to end up with is you're recreating the same workforce over and over again. It's counterproductive to what I think many companies in 24 and 25 are trying to do, which is diversify the workplace, have more equity, have more inclusion. And this sounds like it just goes far the other direction.
Sure, but if you think about it, I mean, so if I take off my employment law hat and I put on my general liability hat, I have clients where they have had employees who are harassing or bullying people online, or they're doing things online that they shouldn't be doing. Signing an ex-boyfriend up for lots of Viagra ads, for example. I definitely don't know anybody that's done that.
On the computer.
But then you find out that they're doing it on their workplace computer or their work dispensed computer that people take home. I mean, we have laptops that are assigned to almost every white collar employee that we take everywhere with us. As an employer, in the general liability context, are you responsible? Are you liable if your employee is using your equipment to harass people or to conduct injurious conduct against other people? So there is that balancing test that I think that you're pointing out. We have to remember when employees get indignant about employers monitoring, that employers do have that responsibility as well, and they could be named in a lawsuit, and they're the ones that have the big insurance policies.
Absolutely. Yeah. And I'm not suggesting that employers should be indignant. I'm just saying that I think that tech, I think we've solved one problem and created 13 other ones, and now we have to go put out those fires. And AI hiring tools are under the EEOC's microscope. So if employers are using them, they better make sure that algorithm isn't yielding discriminatory results. Because I've heard a lot, but saying, well, it wasn't me, it was my computer. It's a sell. I don't know. It'll be an interesting one.
All right. Topic number 3. We are going to continue the saga of talking about the overtime rule and salary thresholds that the Department of Labor tried to issue. And there was a lot of drama in November. And now with the new administration, fill us in, Jackie. What do employers need to know about the exemption for salary thresholds?
So 2024, the salary threshold used to be, and it still currently is, as $684 a week. So in order to determine whether somebody is exempt from the FLSA's overtime requirements, it was a twofold inquiry. You had to look at the duties, but also there had to be a minimum salary threshold that they got paid. That salary threshold has been $684 a week for quite some time. And the DOL raised it in a phased approach, raising that threshold to $844 a week starting in July of 2024, and then up to $1,128 a week starting right now, January of 2025. This would have actually created a situation where a few million people who were previously classified as non-exempt, they would suddenly start being eligible for overtime pay. I think I read that the Department of Labor estimated about 1 million or so employees would have been affected by that increased salary threshold. Except enter Texas, as Texas tends to do. They go big or they go home.
Did Texas
Texas all over this, you know it, and just said, no way. The court ruled that this was an unlawful, this is quote again, unlawful exercise of agency power, concluding that the Department of Labor had exceeded its authority under the Fair Labor Standards Act. And essentially, the rationale behind overruling it was to say that this effectively eliminated a review of what the duties were. And in favor of only a salary test. So what this means for employers now is the exemptions never got implemented. So you can roll it back. If you were planning to convert some of your staff from exempt to non-exempt, that's on hold right now. This is winding its way through the 5th and the 11th Circuit Courts of Appeals. With this administration,
maybe we'll see if this new administration actually assigns lawyers to pursue those appeals. Right?
You took the words right out of my mouth. I don't know where this one's going. Right now, it's dead in the water. But the Texas and the Fifth Circuit have a lot of stuff that I personally am keeping my eye on, and I think that there's people who are listening to this podcast and employers out there who are also, even if they're not aware of the fact that they're interested in what's happening in the Fifth Circuit, they are. Because remember, it was the Fifth Circuit that also banned that non-compete ban, that gutted it.
Oh, yeah. Do you want to tell us about that, where we are with that right now?
You like my little topic shift? I was like,
yeah, I love that.
Pshaw. Let's talk about other ways that your
non-compete
can't work. Do more. Get paid less. Yeah, no, that stalled. That was like the big thing in 2024. Remember when the FTC came in and was like, see ya non-competes. And, it was like a horror movie, like slasher. You see like, ah, ah, ah.
And then did Texas
did its thing. Texas did it. And then Judge Ada Brown said, no, we're going to enjoin that FTC rule banning non-competes. First, she did it just for that plaintiff in that case. And then on a motion to reconsider, she enjoined it nationwide.
She doubled down.
She doubled down, and the FTC was like, I'm not having it. We're appealing this.
And we don't know what the FTC is going to do now with its new commissioner, do we?
I don't know anything ever that's coming out of the FTC. I was surprised a little bit about this one. And, most people who would come to me, and a lot of employers and clients came to me and were like, is this true? We can't have them signed on competes? And then on the flip side, I was getting demand letters from zealous attorneys representing employees who want out of their non-competes telling me, consider this letter our formal notice that this non-compete that they've signed a couple years ago is void, and we're going to take a new job. And I did tell everyone that I spoke to pretty much was let's pump the brakes a little bit on this one. I don't see this playing out over the course of the next 48 hours. And that ball volleyed a couple times over the net. And right now, non-competes are still enforceable. They're still used. They're not void. They still,
depending on your jurisdiction.
Absolutely. They're not per se invalid. They still have to comply with whatever state laws apply to your jurisdiction. They have to be reasonable in scope and both time and geographical proximity and based on your job, so that's all still in effect.
Yeah, it looks like there are a number of states. Florida is not one of them, that actually have started to restrict the usage of non-competes based on the income thresholds for the positions that you're being asked to sign non-competes for. So, for example, Colorado has a requirement that the non-solicitation threshold is 60% of the non-compete threshold. And in 2024, their non-compete threshold was $123,750. So if you made less than $123,750 in your annual salary, you couldn't sign a non-compete. They couldn't make you do that.
Right. And I mean, the logic behind that makes sense, right? Because if you're trying to impede a hourly wage earner from going and working from a competitor, it makes little sense. I do think that that's overkill, and I don't support personally. These are my personal beliefs, which I'm saying, I'm disconnecting from the rest of our views on this podcast from our legal perspectives. But there is logic behind behind trying to get higher. It's not about earning, it's more about your position. It's about what information you're exposed to. It's about what your role was within the company. If you've got access to all of the company's finances, it's trade secrets, it's secret sauce. That's, a restrictable, protectable asset. You don't want that person going off to the next competitor and doing the exact same thing and doing it better.
Okay. Well, so two big developments on overtime and exempt employees, and then also the non-compete issue. It feels like sort of the conclusion to those dramatic legal sagas of 2024. We'll see if there's a sequel in 2025.
I'm watching that one. I love this. I thought the FTC was like Law and Order antitrust unit. I was like all up in that space, and I still am, because I think it affects so many, not just current lawsuits. I think it affects people that are on the cusp but are looking to leave their jobs, and they're just waiting with bated breath to find out, can I do it, and can I do it without the risk of being sued? And just a reminder that when that FTC rule came out, it wasn't just about nullifying the non-competes. There were affirmative obligations on employers to let the staff know, to let your workforce know, by the way, you signed a non-compete and I can't enforce it. So that would have had to have been rolled out.
I know it is a very engaging topic. Perhaps they will soon incorporate AI into non-compete somehow, and we'll find out about that.
I'm going to make you sign a non-compete and vow that you'll never leave me and our podcast and my life and make you your...
Well, the Florida bar prohibits lawyers from entering into non-competes.
No, this is a personal non-compete, Shylie.
Okay.
Like, you
right.
just have to forever be around, and you can go work, free enterprise.
You're stuck with me. You're stuck with me.
This is a personal contract you're entering into.
Okay. Next topic, the next big topic that we think will be a point of conversation at the water coolers and perhaps at the EEOC in 2025 is mental health accommodations in the workplace. And this is a conversation that has been evolving over many years. There certainly is less of a stigma about talking about mental health in the workplace, even in the last 10 years. But what do you think we're going to see in terms of the request for mental health accommodations and discussions of mental health accommodations in the workplace in 2025?
Yeah, this is one that I predict. This was on my bingo card of what I expect to see in 25, because I do think that there's a growing recognition that mental health is a significant factor in workplace productivity, and not just workplace productivity. I think that mental health as couched in terms of what accommodation requests are sought by employees who are dealing with mental health issues. I have seen this come up more and more. And I do think that it's far more likely that most employers are going to have at least one, if not more, employees come to them and say that they have a mental health condition, which can be anything, that's broad. But I do think that from a inclusivity perspective, from a workplace productivity perspective, from an leave and your accommodation policies perspective, mental health is going to be trending this year.
Interestingly, in getting ready for today's podcast, I went to the EEOC's website to look up their enforcement guidelines and enforcement guidance on psychiatric and psychological disabilities.
Yeah, that's been up there a while.
Well, the link is broken now.
Oh, well, it's having its own moment. It's on overload. But it's been up there. The link might be broken, but that's been up there. Psychiatric disabilities and mental health and cognitive disorders have always been one of the frequently most asked questions on the EEOC enforcement guidance pages.
And I think that the shift that we saw during COVID towards remote work, hybrid work, and flex working schedules is going to lay the groundwork to show that these are reasonable accommodations for mental health. If somebody is saying that they need that flexibility or they need to be able to work from home because of anxiety, for example, employers are going to have a harder time demonstrating that that will place a burden on them that they can't accommodate that kind of a request for an accommodation.
Well, they're rolling back. Remember, remote work is now on its way out. Where that pendulum is swinging the other direction. In the beginning, during COVID, remote work was the jam. Everything was remote. But the last few months, you've probably watched on the news that a lot of these companies have issued their policies and their memoranda saying remote work is over. We're going back to the office full time.
Not just these companies, the federal government.
Yeah, come back to work. It works. It only worked for forever. If it ain't broke, don't fix it. I understand what you're saying. I do understand that, you're going to have a tougher sell to say that it's an undue hardship if somebody does need, for example, either a fully remote work or a hybrid remote work situation. But there is never going to be, like with anything else, take remote work out of it or take mental health out of it. As with any accommodation request, there has to be a disability. It has to be an accommodation that allows that employee to perform the essential functions of the job. So the employee still has to show, how is remote work going to allow me to do my job and perform the essential functions of the job? You still have to go through all of that analysis.
Well, speaking of flip-flopping and pendulum swinging, the next big thing that we're going to be watching is the test for classification of employees as independent contractors. So in the Trump 1 administration, we had the big shift of the test from the 6 factors that it had been for forever to the Trump test, which greatly simplified that. We had a whole episode on that. And then in 2024, the Biden administration gave a different test. Are we going to see the Trump administration go back to the Trump 1 administration test? I don't know.
Maybe. I don't know. It wouldn't surprise me. But I haven't heard that that's on the list of like the top priorities. It really wouldn't surprise me as we get new leadership rolling into both the Department of Labor, into the NLRB, into the less so on the EEOC, but especially in the Department of Labor. I think that you might see it. It's conceivable.
Well, it's only been 14 days of a new administration. We'll
happened.
We'll see what happens in week 3 with independent contractors.
Yeah, there's been now how many I think this is the most executive orders that any president has signed in the history of presidents. So,
and so many of them affect the workplace.
Right. I wouldn't be surprised right now if anybody's unfamiliar, if anybody needs a refresher. The independent contractor test it's a 6-factor test that looks at the totality of circumstances. It's no longer just control. Control used to be the primary driving factor, but now there's far more. It's to the extent that your ability to earn a profit. Do you control your schedule is just a piece of it. It's a multifaceted test. And with this test, most independent contractors find that they're not really independent contractors. They're finding that they're actually employees, whether they want to be or not, which was one of the primary criticisms of that flip-flop, which is, I don't want to be an employee. I want to be an independent contractor, but the government stepped in and said, well, too bad. We know what's best for you. Who cares what you want?
Right. Well, the government has its own motivations for people being employees versus independent contractors as well.
Government's got to govern.
Everybody's got an agenda. But there are a number of smaller topics that kind of fall under this last big thing, which again, the times are a change in. In the last 2 weeks, we have seen leadership changes at the NLRB, at the National Labor Relations Board.
Yeah.
With the firing of their chair, and also the replacement of the acting chair of the EEOC is now Andrea Lucas.
Yeah.
So we're going to see some very different agendas coming out of the NLRB that may affect union activity.
Will, not may. It will.
It will.
The last administration's NLRB was it went ham on just everything. I mean, this is Jennifer Abruzzo was the general counsel who gutted non-competes, who gutted severance, who said, pay your employer back, all of these things. They went really hard pro-employee, and it was very hard to get a fair shake on any NLRB charge. And it's still a challenge. Don't get it twisted. But Jennifer Abruzzo really was a pioneer in some respects. When the McLaren decision came out, everyone was like, you could hear the collective gasp come out.
And will you remind our listeners what the McLaren decision was?
Why me? You loved it. You were harassing me about it every day.
Well, you were the one that brought it up.
You can't ask it was severance agreements. It was severance agreements. You couldn't give them severance agreements.
My favorite of the NLRB decisions that came out last year was when the CEO of Starbucks went and was talking to one of their union leaders, and she was just complaining about all these different things. And he sort of said, not directly, but he said, if you're so unhappy here, I mean, you're a barista. If you're really so unhappy with Starbucks, maybe this isn't the right place for you. Maybe this isn't the right culture. And they decided that was a threat.
That's right. Jennifer Abruzzo went and said, you can't tell somebody that they can go find another job. That's a violation.
He didn't say go find another job. He said, maybe this isn't where you're going to be happy.
I know. I'm aware, but that's what we're saying. Jennifer Abruzzo, she had some notoriety, and good on her. She really took her position and she said, I'm going to make the most of it. And I'm going to do the direction that I see this NLRB going. For me, I'm a little biased because I'm a defense employment attorney. So I thought it was overshot. And I thought that this was now going way too far in the wrong direction. I think they're making it very difficult to manage workforces where everything is illegal. It's a little much. It's overkill. I think you're going to see a lot of rollback in 2025, both from the EEOC as well as the NLRB under this administration, just because of how they have framed priorities. One of those, as we know, is Andrea Lucas, as in her role as the EEOC chair.
Yes, I encourage everybody to go to the EEOC website and read her statement that she issued as the acting chair.
Yeah.
She says that she is going to shift the EEOC's priorities to root out unlawful DEI motivated race and sex discrimination, anti-American national origin discrimination, sex and gender-based discrimination, but in a way that it supports traditional gender roles and protects female-only spaces. She's going to be rooting out anti-Semitism and is going to be focusing on other areas of under-enforcement.
Yeah, this is something I think is super interesting because she has said and verbalized that she wants to review the content of, the EEOC Know Your Rights poster, which covers the laws that all employers are required by law to post in their workplaces. She has said that she wants to review the content of that. I know that the EEOC itself has removed the pronoun app from their employees' profiles, which allowed employees to select their preferred pronouns. So I know that that's gone. They're not including certain things, they're really rolling back on gender identity policies, which is not to say that the harassment guidance and enforcement has changed. So employers shouldn't get, if you think that what Andrea Lucas is saying somehow changes the laws that apply to the workplace, do not think that for 1 second, because that is not the case.
All right. One thing also that should be noted about this shift and this idea that they're going to be looking at under-enforced areas, I know that it can be unnerving to some people, but actually when Ruth Bader Ginsburg was a litigator before she joined the Supreme Court, the way that she made change with a lot of laws was she actually took the very non-traditional cases. She took the untraditional plaintiffs. She took male plaintiffs actually to bring sex discrimination cases. And some of the most landmark cases that are used to protect women's rights in the workplace and to make sure that women are treated equally actually started with those non-traditional plaintiffs. So I think it's going to be very interesting to watch and to see what happens with what cases the EEOC starts to pick and what cases the courts are entertaining as more of those landmark cases.
And you're going to see inconsistency. I am telling you, we're going to go back to this one day and I'm going to say, pull the footage, because I think that whatever the EEOC's position is on gender identity, I think it carries really little weight in the courtroom, especially where the Supreme Court has already ruled that courts have to independently decide whether discrimination generally violates Title VII. There's no question that the courts and the court system are going to be have inconsistent rulings between the courts and the EEOC.
But I think that one of the big things that we're going to start seeing even more is that there are certain cities and states, sometimes traditionally considered to be the bluer cities, the bluer states, that are going to be creating more robust employee protections. They're going to be enacting more legislation at the state and at the local government levels to try to respond to this administration and the anticipated or perceived rollbacks of employee protections. So I think that companies, again, are going to have to contend with more of a patchwork application and enforcement of laws in different areas, different rules, and from one county to the next county, one city to the next city where they're working. And so having local counsel, having counsel who really is familiar with the jurisdictions that they are working in or has that strong presence and knowledge to know to look at the local governments, that's going to be very important for employers and businesses as well.
Yeah. And I would encourage everybody not to have this sort of tunnel vision. I think that there's a fear sort of that's been resonating that I've heard when in talking to some, which is, that's it's the death knell to DEI, or it's, my workplace is going to become really discriminatory, misogynistic, or, bigotry. That's not the case. Listen, employers and companies are free to maintain their existing policies, and they're free to amplify their policies and push back in the way that they think is best for their organization. What you cannot do is discriminate on any protected characteristic, whether it be gender identity, race, religion, national origin, you name it. All of these protections are still in play and they have not been disturbed. And I think if you're an employer who wants to maintain a DEI policy, you absolutely can and you absolutely should. And you probably will see states, like you say, that are historically bluer states will probably roll out initiatives to make their policies more robust. But that happens with anything, not just about this. In every year and every change in administration and leadership, states do roll out what they believe to be their sort of priority legislation. And usually in the bluer states, they are more employee friendly. New York, New Jersey, Massachusetts, Connecticut, New England. These states are highly employee friendly to begin with. So I would encourage everybody not to panic on neither side of the aisle, whether employee or employer side.
All right. So what are the takeaways as employers navigate this brave new world of 2025?
Oh, buckle up. Buckle up. It is going to be a litigious ride, this roller coaster.
Go
Definitely.
download some Bob Dylan.
Yeah. I mean, I'm updating handbooks so fast that I don't even know. Might as well be writing the next great American novel. But you need to, from an employer perspective, stay vigilant, consult with your HR professionals, make sure that you're up to date because these things are changing and it's important that you keep up with things. Do things like listening to our podcast, do reach out to your employment counsel, do reach out to your insurance companies, make sure that you've got the right insurance coverage. Nowadays with claims changing so much, you might find that you're not covered for a claim that you thought you were, or there might be a claim we never knew or heard of existed until now. So definitely keep stay in the loop with your insurance brokers, with your risk managers, with compliance. Things are changing, but such is life.
So now I'm going to ask our listeners, what are your biggest concerns from an employment perspective as we sit here in February of 2025? What are the things that you're worried about from a compliance perspective, from a regulatory perspective, from a litigation perspective, from an HR perspective? What would you like to hear from Jackie and me in Litigators Lounge? How can we comfort you? How can we educate you? And tell us your fears, tell us your worries, tell us your deepest, darkest fears, and we will address those in future episodes.
And how can they communicate that to you, Shylie?
Well, you can send emails directly to me or Jackie. Jackie is J Voronov, Voronov at hallboothsmith.com. I'm S Bannon at hallboothsmith.com. Like Steve Bannon, but less felonious. I also have access to our Litigators Lounge at hallboothsmith.com email address. So you can drop us a line that way. And also on LinkedIn. We both have really great headshots on LinkedIn. So come check us out there.
You, Shylie. I hate that picture of me, but
it looks really good.
Thank you.
It looks really good. The lighting is very flattering, and it's soft. There's a mysterious smile. It's very Mona Lisa-esque. Maybe even like the Sphinx in Egypt.
I don't know how I feel about being compared to the Mona Lisa, but I'm going to assume that that's a good thing.
Yeah. Yeah. I mean, everybody. Yeah. Very iconic. Would you prefer Madonna in Vogue? I mean, I could do that one,
No, I'll take Mona.
All right. Well, until next time, everybody, thank you for tuning in and cheers.
Cheers.
Thank you for joining us on Litigators Lounge. This show is brought to you by Hall Booth Smith, helping clients navigate the complexities of workplace legal issues. For more information, go to hallboothsmith.com.
Litigators Lounge is a production brought to you by Hall Booth Smith. This podcast is published for the purposes of providing general information and education on topics which include those related to the law and legal issues. But the contents of this podcast do not constitute legal advice. Listening to this podcast or utilizing the information contained in it in any way does not constitute, nor does it create, an attorney-client relationship between you and Hall Booth Smith or its lawyers. The contents of this podcast should not be used as a substitute for competent legal advice from a professional attorney licensed in your jurisdiction.